Good afternoon, dear participants. Our third session is about private international law aspects of migration. It's my great pleasure to chair this panel today. First of all, I would like to thank everyone who contributed to organizing this event, especially Professor Özçelik. Today's sessions brings together distinguished scholars to explore different dimensions of migration from the perspective of private international law and human rights. Unfortunately, our final speaker was Neşe Baran Çelik. She had to cancel her participation today due to family issues, health issues. We send our best wishes for a speedy recovery. Nevertheless, we will stick to the original program and keep 20 minutes for each presentation. At the end of the presentations, we will have some time for questions and discussions. Let us begin with our first speakers. The title is the presentation is Migration in the Later Life and Adult Protection. It will be delivered jointly by Professor Ece Başsüzer and Assistant Professor Candan Yasan Tepetaş from Istanbul Bilgi University. Professor Süzer is Vice Rector and Full Professor of Civil Law at Bilgi University. Her research focuses on contract law, consumer law, product liability, comparative private law, and international construction contracts. Assistant professors Candan Yasan Tepetaş specialize in private international law and international arbitration. She teaches a wide range of courses in international commercial law and dispute resolution, and she has also been actively involved in international arbitration institutions, including the Istanbul Arbitration Center and the ICC Commission on Arbitration and ADR. Please join me in welcoming Professor Süzer and Tepetaş. The floor is yours.
Bilgin Hocam, thank you very much for your kind words. Good afternoon, distinguished colleagues, dear participants. Let me say how delighted I am to see you all here in this afternoon session. Thank you very much for being here. Many words of thanks already have been expressed today, and I join them, we fully join them. Organizing an international conference of this scale is never an easy task, and this is a perfect job, so we are really grateful for everyone, especially our dearest Professor Gülüm Özçelik and her team. It's a really great job. I would also like to take a moment to thank two remarkable women, the Dean, Professor Başak Baysal, and our dear Professor Gülüm Özçelik. We are grateful for not only their academic leadership, but also for being inspiring, supportive, and genuinely inclusive role models for all of us. To start with, thank you. I will start and then my colleague will continue with our presentation. I would like to briefly frame the subject. Adult protection is no longer a purely domestic legal matter. Increasing mobility, dual citizenship, cross-border employment, and long-term migration have transformed adult protection into a transnational legal subject. This reality, of course, creates complex legal intersections between public law, private law, and private international law regarding the protection of vulnerable adults. I would like to emphasize the demographic background first. As of 2024, approximately 11% of Turkey's population, which is around 9 million, is age 65 and over. Projections suggest that this ratio may reach 25 up to 30% by 2050. These numbers are not merely statistical. They indicate actually a structural transformation of the society. Increased life expectancy brings not only longer lives but also higher prevalence of age-related cognitive decline, such as dementia, as we all know today. It is also noted that 10,000 German retirees currently reside in Turkey, Antalya, and that as of December 2025, approximately 110,000 foreign nationals have their habitual residence in Turkey. These figures demonstrate that Turkey is no longer a merely country of emigration. It has increasingly become a destination for foreign retirees. This growing influx of elderly foreign nationals has important legal implications. As a result, Turkey is really emerging as an important jurisdiction in the field of protection of vulnerable adults, not only for its own citizens, but also for substantial and growing foreign elderly population. For this reason, advocacy, flexibility, and human rights alignment of adult protection law are no longer purely domestic concerns. They are matters of increasing international relevance. Within the European Union, there is an increasing level of harmonization, and Hague Convention is really helping to do so. However, Turkey is not a party of this convention. This brings us to a crucial question. What explains the structural differences between European Union legal systems and Turkey in the field of adult protection? The answer lies in the philosophy of the legal framework. In Switzerland, which is also our code of codification, source code of codification, we changed our route from them in this adult protection subject. In Switzerland, adult protection is built on self-determination principle, which enables proactive planning for future incapacity. In a system grounded with self-determination, core values are such as party autonomy, human dignity, human rights occupy a central position. The adult is seen as an active rights holder and should be able to shape their own future, own legal future. By contrast, under Turkish law, the framework remains largely paternalistic with traditional guardianship mechanisms. Turkish law is fundamentally structured around restriction and state protection. The primary objective is not to empower the individual in advance, but to intervene once the vulnerability has been identified. The available protective measures under Turkish law are limited, strictly regulated by the states, and dependent upon a court decision. Most importantly, they operate through legal incapacity. This structural divergence explains much of regulatory gap that we discussed on the previous slides. Let's have a closer look. Let's have a closer look to the modern Swiss law approach. Following its major reform under Swiss law, Swiss adult protection law has shifted away from the traditional guardianship structures and replaced them with a system centered on self-determination and tailored intervention. Two principal instruments embody this approach. First, the private mandate, which allows legally competent adults to appoint a person, it could be a natural person or a legal person, to manage her personal, financial, or legal matters in the event of loss of discernment. Second, the advance directive, which helps to determine the future medical treatment preferences or designate a person who will help on these healthcare decisions. With these instruments, the adult defines who will act on their behalf, in which areas they will act, and according to which instructions. Only if such voluntary measures are absent or insufficient does the Adult Protection Authority intervene. And even then, the authority must tailor the protective measures to concrete needs of the individual, ensuring proportionality and minimal interference. Thus, the Swiss model does not eliminate protection, it actually reframes it. The autonomy is the starting point, and state intervention becomes subsidiary. Also, it is in connection with, we all know this principle, favor testamentii, since both are actually the last wishes, last expressed wishes. This structural logic aligns with contemporary human rights developments as well. Now, turning to the Turkish law model, the Turkish system remains fundamentally paternalistic because it's structured around judicial restriction and state provision with guardianship mechanisms. Adult protection is implemented primarily through the limitation of legal capacity, followed by appointment of the guardian. There is, unlike the Swiss system, Turkish law does not recognize any framework for anticipatory self-planning. So while this framework undoubtedly aims to safeguard vulnerable individuals, it reflects a paternalistic logic. The adults primarily view as someone to be protected by the state rather than an autonomous agent capable of shaping their own future. Now, in theory, we can say that it may be possible, really say that some voluntary measures exist in Turkish law, but it's only on theoretical level. Turkey is a part of Oviedo Convention, and Oviedo Convention is fundamentally grounded in the principle of party autonomy. It recognizes the importance of previously expressed wishes and seeks to respect individual self-determination, particularly in the medical context. However, the Convention does not impose any binding obligations regarding the implementation of these comprehensive adult protection mechanisms. It does not require states to establish structured systems such as private mandate or advanced care directives with full civil law effect. We actually see this result, this non-effectiveness result in a survey which is conducted in 2018 among healthcare professionals. Almost 35, when asked whose decision should prevail in cases where a patient is no longer able to express their wishes, 35% of the participants stated that the decision should belong to the legal guardian. Almost 30% of the participants stated that the decision should be patient's doctors. 30% said that a medical committee should decide, and only 5% of the healthcare professionals stated that previously expressed wishes of the patient should be followed. These results are quite striking. Despite the formal recognition of previously expressed wishes in the Oviedo Convention, we saw the practice and there is no effect, no literal effect. The principle of authority may exist on paper, but without binding mechanisms and institutional reinforcement, it remains largely ineffective in real-life decision-making processes. Finally, we have to accept that cultural maturity and the level of societal awareness are also crucial for the effective implementation of such person-centered legal norms. Laws that directly affect human dignity, vulnerability, and life decisions require not only legal reforms, but also corresponding cultural and ethical readiness within the society. In conclusion, this structural divergence creates a concrete risk, especially when we're talking about a foreign who lives in Turkey. At the time when I speak of foreign element arises, I would like to leave the floor to my colleague, Candan Yasan Tepetaş. Thank you very much for your attention.
Thank you, Ece Hocam. There is too much to discuss, so let's dive in immediately. As you know, a dispute falls within the scope of private international law when there is a foreign element and when there is a private law dispute. In our case, the fact that the person is a foreign national causes the existence of a foreign element. Private international law problems arising out of migration in later life can be classified into three groups. Yes. The first one is the determination of the international jurisdiction of Turkish courts. Second one is the determination of the applicable law. And the third one is the recognition and enforcement of foreign judgments, court judgments especially. Our primary source to deal with this problem is the Turkish Private International Law Act, numbered 5718. Although Article 1, Paragraph 2 of our Act reserves application of the International Convention, as my colleague already mentioned, Turkey is not a party to the Hague Convention on the International Protection of Adults. Therefore, private international law problems related to the migration in later life shall be exclusively dealt with our Private International Law Act. Regarding international jurisdiction of Turkish courts, we have a special provision on jurisdiction, namely Article 42. Article 42 designates the international jurisdiction of Turkish courts limited to certain matters, including guardianship and restriction of capacity of foreigners. According to this rule, the jurisdiction of Turkish court is established in case if the person resides in Turkey, or alternatively, if the assets of this person are located in Turkey. That could be movable or immovable assets. It doesn't matter. When the Turkish court has jurisdiction, our second problem is the determination of the applicable law. We have Article 10 of Turkish Private International Law Act. And the first paragraph of these provisions designates the national law of the person as the applicable law for the grounds for making the decision regarding a guardianship or restriction of capacity. This means that for a German citizen, for instance, German law shall be applicable. However, our problem arises out because of the third paragraph of Article 10. Because Article 10 of the third paragraph is problematic and it causes a split regarding the applicable law. According to this provision, except for matters related to the decision for terminating or taking guardianship or restriction of capacity, all other matters, such as management, execution, everything, shall be exclusively governed by Turkish law. As a result, a private mandate or an advance directive can be established under the national law of a foreign person, let's say German law or Swiss law. However, the management of this private mandate or advance directive shall be subject to Turkish law. It is clear that this solution causes significant problems because, as my colleague already told, Turkish law doesn't recognize voluntary measures. There is no provision in our Turkish Civil Code regarding adult protection or voluntary measures or their enforcement. So, existing Turkish provision on guardianship or restriction of civil rights are not fit at all for a private mandate or advance directive. So, what will we do? Let me start with the problem. Actually, Turkish Private International Law Code does not contain neither a specific provision, a specific conflict of law rules especially, on a private mandate or advance directive. Under Turkish law, let's say Lex Fori, a guardianship is classified as an institution belonging to both private law and public law. It's a mixed institution. However, voluntary measures differ significantly from these institutions. So can we fix this deficiency by interpreting voluntary measures as a form of representation, for instance? If we adopt this representation solution, The applicable law to a voluntary measure shall be designated by Article 30, paragraph 2. However, even if we accept this solution, the applicable law remains still Turkish law. So Article 30, paragraph 2 does not neither help us. The answer will be almost the same if we refer to conflict of law rules on contractual obligations. So let's discuss whether we can fix the problem through enforcement and recognition of mechanism before Turkish courts. The question is the following: can we enforce a private mandate or a voluntary measures by seeking enforcement decision through Turkish courts? However, Turkish Private International Law Act only allows the enforcement of foreign court judgment. So we have to have, at the first place, a court judgment. In our case, there is no foreign court judgment. We do not have a foreign court judgment in case of voluntary measures. For this reason, the enforcement of voluntary measures is not possible due to Article 50 and following provisions of Turkish Private International Law Act. Nevertheless, in our system, we have also some limited exceptions, some limited provisions, such as provisions in Civil Registry Act, allowing the enforcement and recognition of administrative decisions on divorce or adoption, for instance. But concerning voluntary measure, we do not have such provisions. As a result, in light of current system, current provisions of Turkish law, available at least, it does not appear as possible to implement, to enforce a voluntary measure in Turkey. So what is our proposition against this problem? We have two propositions. The first one is to include a special provision in the notary regulation. This can be emergency help, let's say.
A quick solution.
A quick solution, a prompt solution to fix some temporary problems. Because a special provision in the notary regulation may allow the Turkish notaries to determine the validity of voluntary measures. However, the real solution can be only made through a legal reform. And this solution has twofold. The first one is to modernize the Turkish Civil Code regarding its provision on adult protection and adopting a new adult protection system similar to civil law. And the second one, it's a necessity for Turkey to ratify the Convention on International Adult Protection. Due to this convention, a power of representation related to a voluntary measure will have the force of law in Turkey as a contracting state. Thank you very much for listening, and thank you for your attention. Thank you. Thank you.
Oh my God, it's a very technical issue. It's always hard to establish connection between these issues and migration matters. Thank you very much. It's very insightful for me. I hope you find it the same. Okay, now I give the floor to Associate Professor Elif Çelik from Eskişehir, Osman Gazi University. Her presentation is titled The CRC Committee and Individual Applications in Child Migration Cases.
Yes.
Dr. Çelik's research focuses on the theoretical foundations of human rights and human dignity and vulnerability, as well as the jurisprudence of international human rights bodies and the protection of vulnerable groups. Please.
Thank you.
Well, it's yours.
Thank you so much. Thank you for having me here. So, I've got a confession. I don't study, I don't work in migration per se, but, well, this opportunity was something that I couldn't, resist, and hopefully I can make you understand why. So I'm going to start by talking about the Convention on the Rights of the Child, and then I'll get to my issue. So, since its entry into force, the Convention on the Rights of the Child has guaranteed rights to every child under a state's jurisdiction without discrimination based on nationality or migration status. The Convention recognizes children as independent right holders and protects a wide range of rights. Article 22 of the Convention, which is specific to asylum-seeking and refugee children, also ensures protection and humanitarian assistance. And the CRC Committee, in its general comments, has further clarified that all children in migration situations should benefit from these measures. For many years, however, the CRC Committee system relied mainly on periodic state reports. This model did not give children a direct way to bring their complaints and was not well suited to address urgent and individual situations, especially in contexts where harm can occur quickly and decisions are difficult to reverse. In this sense, the adoption of the optional protocol on communications procedure marked an important development. Currently, this procedure enables children or those acting on their behalf to submit individual complaints to the committee, to request interim measures, and to obtain an international review of child-related decisions. It transforms the CRC from a monitoring framework into a remedial mechanism that is capable of responding to immediate risk. This becomes particularly important in migration cases where domestic remedies may not be accessible, may not suspend deportation, or may fail to take children's specific vulnerabilities into account. Still, it should be noted that the protocol has limited acceptance. While every state in the world except the United States has ratified the Convention on the Rights of the Child, far fewer states have accepted the third optional protocol establishing the individual communications procedure. The procedure under the optional protocol has a distinct place within the UN treaty body system, it appears. What makes it different is not that it removes procedural rules, but it interprets them through a child-centered lens. The committee takes into account principles such as the best interest of the child and evolving capacities when assessing admissibility. For example, it does not strictly require the child's consent when a submission is made on her behalf, or as long as it is in line with the best interest principle, and that it would be unrealistic to expect such consent. It also considers whether domestic remedies were genuinely accessible to a child, particularly in situations involving detention, dependency, or migration vulnerability. A key feature of the communications procedure is its flexible approach to standing. The system does not rely on rigid assumptions about legal capacity. This is particularly important for the unaccompanied and separated children because at the domestic level, they often face serious barriers such as lack of guardians, limited legal assistance, and complex asylum procedures. Although children can submit complaints themselves, in practice, many cases are brought by parents or legal representatives in situations involving deportation, Dublin transfers, age determination, or family unity. Even though the complaint is formally framed in the name of the child, its protective effects often extend to other family members. The committee recognizes that the best interests of the child cannot be assessed in isolation from the family context and relationships. Protecting the child, therefore, requires protecting the family context. So, what does all this get to do with migration, one might ask? Migration and asylum procedures clearly create a particularly difficult environment for children's rights. But still, when I was first curious about the committee's decisions, migration was not what I had on my mind, and I was really struck by, and honestly disappointed by the large number of cases which dominated the overall caseload of the committees. Reasons for this dominance, however, is understandable. Decisions about entry, transfer, detention, or removal are often taken very early, and even though the best interest principle is formally recognized, there's often no structured process to determine what those interests actually require. For children, these early decisions can have immediate and long-term consequences, including deportation, family separation, placement in adult facilities, and inadequate reception conditions. Although domestic remedies may formally exist, they are frequently ineffective in practice. Appeals may lack automatic suspensive effect, legal representation may be unavailable or delayed, and procedural rules may not be adapted to children's capacities or needs. In this context, children may only be heard after decisions with far-reaching consequences have already been implemented. So, the individual communications procedure under the CRC responds to these shortcomings by offering children access to an international body that approaches cases differently from domestic authorities. While national administrative and judicial bodies often focus on whether the past events have been sufficiently proven, the Committee on the Rights of the Child places greater emphasis on assessing a child's specific vulnerabilities and the risks a child may face if a decision is implemented. I will now get to the cases, but as it is impossible for me to, review all the committee's cases, I'm going to focus on some of the main themes that I could come up with and findings regarding some countries. So, one group of decisions concerns deportation cases in which female genital mutilation is at issue. In several cases against Denmark, the committee has developed a consistent approach to assessing children's protection under Article 3 and 19 of the Convention, which concerns the principle of best interest and protection against violence. In these cases, the state of Denmark has repeatedly argued that parents, and in some cases even single moms, parents, were capable of resisting the social pressures to subject their daughters to FGM. However, the committee emphasized that a child's protection cannot depend solely on the perceived strength or resourcefulness of the parents. Instead, it examined the widespread prevalence of FGM in Somalia, the limited effectiveness of legal prohibitions, the specific family circumstances, and the need to apply the precautionary principle where reasonable doubt exists. Another group of decisions concerns age determination, which is one of the most decisive issues in child migration cases. Since being classified as a child determines access to guardianship, child-specific reception conditions, education, protection from detention, and protection against removal. According to European standards and others, when there are reasonable grounds to believe that a person whose age is unknown may be a child, or when a person claims to be a child, that individual must be given the benefit of doubt and treated as a child until an age assessment procedure determines otherwise. In practice, however, age assessment is often marked by uncertainty, contested evidence, and procedures that prioritize administrative efficiency over rights protection. The committee's case law, particularly in cases against Spain, has addressed this issue in detail from the beginning. A considerable number of cases against Spain, which was 14 as of 2022, established that age determination is a decisive gateway procedure that must fully comply with the child's rights safeguards. In these decisions, the committee held that official identity documents must be presumed valid. Refusal to undergo bone testing cannot justify declaring someone an adult, and the absence of a guardian during the process constitutes a violation of the Convention. The committee also criticized reliance on medical bone tests as the primary or sole method of age assessment. It highlighted the scientific limitations of these tests, noting that some of these are outdated, based on limited reference populations, and may result in systematic overestimation of age, particularly for non-European children. Age determination, the committee stressed, cannot be reduced to a purely medical exercise. It must be a holistic legal process that takes into account documents, personal statements, a broader contextual factors. A central element of this jurisprudence is the principle of the benefit of the doubt. Where uncertainty remains, the individual must be treated as a child. Failure to apply this principle may lead to a placement in adult detention facilities, denial of guardianship, and an increased risk of removal. In several cases against Spain, the committee also issued interim measures requiring the state to refrain from deportation and to transfer applicants to child protection facilities, recognizing the misclassification itself may create irreparable harm. Sorry. These cases demonstrate how the individual communications procedure addresses age determination not simply as a technical issue, but a core child's rights concern. Recent cases also show that deportation decisions concerning parents have been challenged before the committee when they lead to children being separated from their parents. Applicants argue that such deportations violate the child's right not to be separated from his or her parents and fail to properly consider the best interest of the child as required by the Article 3. Another important theme concerns the use of interim measures under Article 6 of the Optional Protocol. The purpose of these measures is simple: to prevent irreparable harm. The committee's practice shows that interim measures function not only as procedural safeguards, but also as concrete protective tools. In some cases, the measures have led to suspension of deportation orders, the granting of residence permits, and the protection of family situations even before a final decision on the merits. In situations where a state failed to implement interim measures, the committee noted that such failure itself constitutes a violation of Article 6 of the Optional Protocol. These cases demonstrate that interim measures operate as a preventive tool, allowing the committee to intervene at a moment when domestic remedies have not yet reached finality, but the risk of harm is imminent. Their effectiveness can also be observed in the number of discontinued cases before the committee, because around 1/3 of the cases before the committee apparently result in discontinuous decision. Given that the majority of cases concern migration, this is not surprising. Discontinuous often occurs because the state changes its position or grants a residence permit, or the applicant reaches adulthood, or contact with the applicant is simply lost. Interim measures also play an important role in this outcome. In some situations, a communication is effectively resolved simply through the granting of the measures. So, the individual communications procedure has shown significant corrective potential in migration and asylum contexts concerning children. Through interim measures, the substantive findings, the committee so far seem to have prevented deportations, preserved family unity, and challenged flawed age assessments practices. Its approach remains consistently child-centered and attentive to vulnerability. Yet the striking reality is that one would expect that matters brought before a safeguard mechanism established under a convention explicitly centered on the child would rather reflect rights and freedoms specific to children. However, the overwhelming majority of applications concern migration, an issue usually we associate with adults. This may reflect the global reality of migration. At the same time, it may suggest a mechanism designed to guarantee children's rights in practice, also being used to address the helplessness experienced by adults as a result of state policies. Undoubtedly, certain tools offered by this mechanism, particularly interim measures, have the potential to prevent irreparable harm in protection of children in migration situations. Nevertheless, the volume and nature of the applications indicate that the mechanism has, in many respects, evolved into something resembling a migration law procedure. In my view, this also reviews the structural obstacles to making children's rights truly effective. From whichever perspective one approaches it, the situation remains deeply thought-provoking. Thank you.
Thank you so much for your insightful presentation. Yeah, it's vulnerable groups. It's always women and children, and my heart goes for them. They are always victim of war and migrations, this kind of event, incidents. So we have to do more for them, I think. Now,
Hi, can you hear me?
yes, we can hear you clearly, Stefano. So, our next presentation will be delivered by Associate Professor Stefano Dominelli from the University of Genoa, if I correctly pronounce it. I don't know. Stefano will be joining us online, as you seen on the screen. And his presentation is titled Migration and Personal Status, Conflict of Laws as the Road to Change. Again, very technical issue for me and for our participants, I think. Professor Dominelli is a specialist in public and private international law and has extensive experience working with European institutions, including the Council of European Union and European Judicial Network in civil and commercial matters. His research focuses on EU international civil procedure, conflict of laws, and the protection of weaker parties. Please join me in welcoming Professor Stefano Dominelli. The floor is yours.
Hi, can you hear me?
Yes, we can hear you.
Yes, hi. Okay, sorry. There is only one microphone on and I cannot hear very good, but sorry. Now that I know that you can hear me. First of all, I would like to thank the organizers for organizing this incredible and very important event, and I would really like to apologize for not being able to be in person today. I am truly sorry. So thank you again for everything, also for giving me the possibility of presenting online. It has been very nice and very kind. I really appreciate it. Thank you. This being said,
Sorry
if
to
I will share my
Stefano.
screen just
I would
to
like to
show
ask
you
audience,
the presentation that I have. Just
Okay.
Ignore the mess on my desk as I usually do.
Doesn't work.
What I would like to do with you today, very briefly, is
Stefano?
to have a talk, to have a chat about
Stefano?
very specific
I
issues
check.
and conflict of laws
Such-
in terms of conflict of laws as a way or as a tool to change how we deal, how we manage immigration. And the main aim that I would like to discuss with you today are, on the one side, to
I think
clearly
it's okay.
state that, contrary to what we usually teach, private international law is not a simple technical field. This might come with little surprise to some, but it's how we usually introduce our classes based on traditional approaches. Or on the other side, as we could say, or we can frame it in another way, what I would like to do with you today is to talk about the political value that private international law has and how private international law can promote or be an obstacle to given policies. This also means that if we conceptualize the field of private international law as a tool for foreign policy, internal policy, then we can also manipulate the field of private international law to obtain a given result. And about these possible manipulations, I would like to make some general warnings, just to know that we can do that, and then states can decide whether or not they want to do that. And then what I would like to do is also to highlight that when we deal with private international law, especially migration issues, there is indeed some sort of political discretionality that states want to preserve. And if we keep that in mind, then any private international law solution that we come up with, it must have a realpolitik approach and ensure that we do not touch this discretionality that states want to preserve, otherwise they will simply dismiss our ideas. The starting point is the assumed neutrality of conflict of laws. Pont-Savigny spoke of localization of relationships, and we know now that this is not necessarily true. Conflict of laws was traditionally seen as a system that was simply meant to, or not meant to create rules as such, but only validate rules. So in this sense, conflict of laws was thought to be neutral, and this problem of neutrality has clearly fallen. If we take a comparative approach, if we take a comparative view, and we look at the case law of Italy or Germany, for example, we now perfectly know that courts are well aware of the fact that private international law is not neutral. And I think that the Italian rules of private international law related to the more difficult separation and divorce are quite the example of this, because in the past, we used to regulate personal relationships between spouses under the rule of the husband. And following the intervention by the Constitutional Court, we have switched to what seems to be a more neutral connecting factor, that is the basis of mutual localization of family life. And conflict of rules, I think, it has already proven to be a tool for politics, for internal politics in Italy. As probably many of you already know, Italy follows the Mancini approach, which means that matters of status are strongly related to nationality. And I had to deal, when I was working in the law firm, with a problem that I had two persons, two parents. They were both Albanian nationals. They were both born in Italy, but never applied for the same nationality. They decided at a certain point to divorce, and they also had a child. And if we took the rules of private international law, all these relationships were governed by Albanian rules. But the parties, to be honest, since they were born and raised in Italy, they absolutely did not expect their divorce or their relationship with the child to be regulated by Albanian law, to which they had basically no comparison to Italian law. The thing that we still implement the nationality connecting factor as international law is seen as an obstacle for integration of those migrants that habitually live in Italy and do so for long years. To somehow ensure that we have greater integration, that we treat foreigners as nationals, we have changed the narrative. It is very difficult in Italy to obtain the nationality with families, with stories, and the traditional approach. And so to avoid using the word nationality, scholars have said that in private international law we should switch from nationality as a connecting factor to habitual residence as a connecting factor in matters of status to ensure integration of foreigners in Italy. And Germany, to some extent, has done that, at least in so much Article 7 makes the Geschäftsfähigkeit regulated by the law of habitual residence. Scholars have proposed to change private international law to increase integration, and the response by the Italian legislation or by the Italian legislator has been very peculiar, because the legislator did not change private international law to integrate foreigners, but the legislator changed the Italian law on nationality to exclude Italians that have weak connections with Italy. In particular, since 2025, we now have a limited iure sanguinis acquisition of nationality. So it seems like the Italian legislator somehow got knowledge of the potential of unlocking private international law in migration matters and acted accordingly to close the system somehow by even excluding descendants of Italians from having the Italian nationality. This probably also, there is also the reason that we probably risked having more voters abroad than in Italy. In this sense, it is clear that conflict of laws in general terms, it's not particularly suited to manage migration questions, to ensure greater integrations. The Court of Justice of the European Union is fully aware of that, and the Court of Justice, as we all know, it's pursuing a different path, that of functional recognition of foreign status, at least to enjoy EU-derived fundamental rights. We have Coman on same-sex marriages, Panciarevo on the recognition of the parent-child relationship, Mirin on gender markers, and Trojan on same-sex marriage again, but with a weakening of the functional approach. And to show that private international law also has a political side, a political aim, and a political consequence, some authors have argued that private international law has not been effective in managing migration issues and recognition of status issues, but Italy, in that case, I think it's a good example to the contrary, because, for example, in Italy, it was very difficult to obtain a divorce. It was very long, very expensive. But then following Brussels II regulation, the Rome III regulation, with the operation of private international law, we simply had to recognize divorces abroad, even though they were light divorces, they were quick divorces. And so those who had the possibility to get a light divorce abroad were in the position to have that light divorce recognized in Italy in a short period of time. This led to the consequence that Brussels II and Rome III created a market of laws, and there was a race to the bottom in the sense that even the Italian legislature abandoned its traditional stance on divorce and created new rules under which it's easier and really cost-effective to obtain a divorce. And this has only been possible because we were already recognizing quick and light divorces from abroad. So in this sense, private international law, more specifically the recognition of decisions, has already led to social change in a way in Italy. And I think that due to this event, Italy is now opposing evolutions of private international law. Italy has fully understood the potential of private international law, and since it wants to keep a certain internal and foreign policy, Italy is now fighting for further revolutions in private international law. And the proposal by the European Commission of a regulation on the recognition of the parenthood lawfully created abroad, it's a clear example. Italy has the fear that such a regulation proposed by the European Commission may be the backdoor for the recognition of surrogacy agreement. It is a very strong political stance of Italy not to recognize surrogacy agreement. Italy fears that private international law will be the door to such agreements be recognized in Italy. So Italy is simply blocking all the evolution in the field in private international law. So just as a conclusion, what I would just like to stress is private international law can be a tool to promote substantive values, as the European Commission is doing, with the parentage proposal as it has happened with the recognition of divorce. But private international law is also consistently used as a way to oppose some values, some evolutions, just as we regularly do in the field of migration. This is just to say that conflict of laws has a strong political side and political use, and if we want to think of new possible private international law on how the field should manage migration, we really have to keep into consideration that states will react to any solution to save their position and will act accordingly. Thank you very much for your attention, and I would love to hear from any questions or consideration.